All right, so why should I give him 5 years? The complainant in this case is the same complainant that he has the new case on.
There was some other things going on in his home life and stuff. I believe he's had some family health issues and stuff.
No, I mean, because he hasn't learned anything. And I don't know what's happening in his relationships, but it doesn't appear he's learned anything. And I don't know why I should sentence him to just 5 years. All right, the court is going to sentence you.
This guy walked into court like 5 years was a reasonable price to pay for what he did. In his mind, that number wrapped everything up nice and neat. Case closed. But what he conveniently ignored was the fact that this wasn't his only assault case. There was a second attack on the exact same victim, and somehow he expected both cases to be treated like one package deal, the moment the judge started digging into the details. You could feel the tone of the hearing change. This wasn't just a one-time mistake or a bad night gone wrong. This was a pattern. And it's hard to understand how someone can seriously hurt a person they claim to care about, not once, but twice, and still walk into court with that kind of confidence. I want to hear what you think. Is 5 years ever enough for repeat violence like this? Or should someone like this face the maximum possible sentence? Let's get into it.
Calling 2025 CR 01152. Could I have parties announce?
Your Honor, there's also the MTR.
Yeah, I'm going to take this up first.
Can we do the MTR first?
Why are we doing the MTR first?
Uh,
And are you Mr. Gary?
Yes, ma'am.
Counsel, you received all discovery.
Yes, I have.
Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. By entering into a plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea today?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, freedom of information, and rights under Article 1.051. By information, you're charged with assault family household member with a previous conviction. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,500 fine. Did you understand that to be the plea?
Yes, ma'am.
State?
There is, with the exception of, I had put restitution, should there be any, I know that he would be entitled to restitution here.
All right, it's gonna be restitution if any. Let me just tell you, if they're sending you to prison and your counsel is waiving a PSI, then whatever that restitution amount that person claims, that's gonna be the restitution amount. And when you're up for parole, they'll take it up with parole. Do you understand?
Yes, ma'am.
All right, restitution, if any, to Anessa Nicole Guerra. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated primary custodial parent?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, at this time, state orders into evidence, states Exhibit 1 with all attachments.
No objection, Your Honor.
Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, was kind of a tough decision for Mr. Geary to come to, but he thinks it's in his best interest and he would ask the court to go along with the plea bargain that it's taken us quite some time to negotiate, but I think he wants to get this behind him. It's unfortunate that we've ended up here, but I think he is ready to move on and become a productive citizen once he gets this behind him.
All right, the court is going to sentence you to 5 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Anessa Nicole Guerra. There's a $1,500 fine. State is taking in consideration 2025 AL 006681, 2025 PF 31338. And this will run concurrent with 2020 CR 12202. And there's to be no unsupervised contact with minors. Is there anything else with regards to sentencing?
No, no. No, Your Honor.
Just that whenever we're finished with this and the MTR, we have the victim present who wishes to do victim impact statement.
Okay. All right, we're proceeding with 2020 CR 12202. Are you the same Juan Carlos Aguirre Jr. who was placed on deferred adjudication in 2020 CR 12202?
Yes.
For the offense of assault, family choking, strangulation on March 3rd, 2021 for a period of 3 years. Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, violation of condition number 15 on or about the 12th day of May 2021 in Bear County, Texas. The defendant, Juan Carlos Aguirre Jr., did then and there fail to attend, comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following counseling education program, state accredited battering intervention and prevention program in violation of condition number 15.
How do you plead to that? True or not true?
This next part is what really stands out to me. We're talking about a second violent assault on the same victim. Yet the discussion somehow shifts to whether the sentences should run at the same time. That just doesn't add up. If someone is already on probation for seriously hurting another person and then turns around and does it again, why should that be treated like one single incident? Situations like this are exactly when courts usually send a strong message, because it shows the first punishment didn't change anything. Cases like this can make victims feel like the system isn't protecting them. This was someone who had already been given a chance to turn things around, and instead chose the same path again. If there's ever a situation where consecutive sentencing makes sense, it's one like this. What do you think? Should repeat offenders ever get concurrent time, or should the sentences always be stacked?
State will waive the remaining violations, Your Honor.
Any objection?
No objection.
Did you understand by pleading true to violation of condition number 15, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 15?
Yes, ma'am.
Court will find violation of condition 15 true. Is there a proposed agreement?
There is, Your Honor. That is to revoke the defendant's probation, adjudicate him guilty, and sentence him to 5 years TDC.
All right, so why should I give him 5 years? Because the complainant in this case is the same complainant that he has the new case on. And so why should I do this?
Judge, if we're speaking about this probation, this deferred adjudication, Mr. Geary was doing the things he was supposed to be doing at the time. He was enrolled in BIP. In fact, if you look at the records, I believe he did all but 4 classes of the BIP. But because of other circumstances, the MTR was filed on him, and he did not complete it. There was some other things going on in his home life and stuff. I believe had some family health issues and stuff, but he was doing the things he was supposed to be doing. He just didn't complete it because of the circumstances. So that makes him not a good candidate for probation. But I don't think to punish him in excess for something that's occurred after this probation expired is fundamentally fair on the original deferred.
No, I mean, because he hasn't learned anything. And I don't know what's happening in his relationships, but it doesn't appear he's learned anything. And I don't know why I should sentence him to just 5 years when he's been sentenced on assault family household member with a previous conviction, which means there's a previous conviction, and it's against the same complainant that he's on probation for. State, why should I give him 5 years?
It just seemed that in the best interest, considering, yes, it's the same victim, but for efficiency of judicial purposes for both cases to run concurrently together.
All right, this is what the court is going to do. The court is finding 15 true. The court is going to grant the motion, find you guilty, revoke, sentence you to $1,000 fine, time and money run concurrent. There's an affirmative finding of family violence. This will run concurrent with 2025 CR 011524. There's to be no contact with Anissa Guerra. There's to be no residing in a household with minors. There's to be no unsupervised contact with minors, and the court is going to sentence you to 8 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, for the most
You do
part.
have a limited right to appeal. That right to appeal is that as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence and a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, you're gonna have to start making better decisions. Otherwise, you're gonna find yourself in and out of somebody's prison. You understand?
Yes, ma'am.
And your relationship with her is over.
Oh,
You
yes,
understand?
ma'am.
All right, good luck to you.
Honestly. When you really think about what this victim went through, twice even 8 years can feel like too little too late. But seeing the judge go beyond the plea deal at least showed that the court wasn't willing to treat this like a simple mistake. It's a reminder that when violent behavior becomes a pattern, the justice system eventually stops offering second chances more than anything. I just hope the victim finally gets some peace and distance after all of this. Nobody deserves to live in fear, especially from someone who keeps proving they can't control their actions. And while 3 extra years might not sound like much to some people, that's a long time when you're sitting alone with your decisions. With a maximum sentence of 10 years on the table, I'm curious what you think. Was 8 years enough? Or should the judge have gone all the way to 10? Thanks for watching. Don't forget to like and subscribe. Your comments and feedback really help improve these videos, and I appreciate every single one of you.